Yeah. Declaration of Counsel on the 6th day of July, 2018, Brett Roberts. The response to the defense motion is available in a straightforward analysis of available case law. Yeah. Matter need not be dismissed due to a lack of personal service because service of an order is not an element of the crime of violating a no contact order. City of Auburn versus Solis Marcial. Yes. Well, Deputy Prosecuting Attorney. Um, is it a matter of the service of an order to have the element of a crime of already being able to prove that the arrest that I experienced in 2016 was a fraudulent arrest where I should not have been arrested because nobody would admit the evidence? Now, if they dismiss the case as in a mistrial for no one admitting the evidence in Clallam County, exactly how can you prosecute me for violating a protection order that was used for a false arrest, false imprisonment, harassment, torture, and deceit? Now, maybe you need to look at your argument again because I can prove I wasn't in Brennan, Washington, and an email sent by Mr. Budnick, Friday, June 16th of 2017. Do you think I would have been emailing that previous year if you had actually admitted the evidence? Now, regardless if she had gotten an email from me or not, because she didn't, yes. When one law enforcement department refuses to admit the evidence of the innocence of the accused, yes, because they just can't do it. And then the judge refuses to declare a mistrial because it would make them look bad, because then they'd have to remove this protection order because it was a false police report, a false arrest, and a very deceitful interrogation. Now, if you stupid fucks would understand that you are adding crime upon a crime upon a crime upon a crime, you all are complicit in the conspiracy to deprive innocent Americans of their rights. Now, I know it's not an element of a crime unless the element of the crime is that you've already been previously arrested for the crime of violating it when you weren't in that city, and there was a lot of evidence to prove that. Numerous video cameras from numerous different buses throughout the whole day. And then the emails that were sent that day. Oh. So if Jefferson and Clallam County could do just the simplest of things, they could actually investigate the innocence of the accused. I would say that Judge Landis could declare a mistrial because of the obligation of the mistrial in 2016, so that there was no possible way that you could find me guilty of violating it. Oh, now, see this motion for default? Yes, that was against the law. See the arrest that took place on May 27th? Yeah, it was against the law to serve me and have me arrested at the same moment. See this declaration of mailing for this court hearing and this court hearing? Yes, yes, yes. Without proof of actual mailing, right? Not just declaring that you sent something, but having somebody sign that it actually was received by a responsible party that would have given it to the respondent. Yes. You cannot include it as a justification for issuing a dissolution of marriage. Now, this is something that we really need to think about, okay? You can't believe every person that motions a court. Now, see, this may serve response by mail and publication. Mail and publication. Now, mail returned unclaimed. Yes. Well, you have an obligation to make sure that if somebody says that they sent something to Judge Landis, notice of court hearings, yes, that you wait and make sure they do get the actual notice before you issue a failure to appear. Because as the deputy prosecuting attorney said, he did have notice that you did not have notice. I did know that you were having a court hearing. The actual law says you are required to serve me. So your fucked up way of saying, well, we can do whatever we want with the vaguest of interpretation of the requirements of law. Pooch. He had a screen print from the Washington State Court site, but it says there's no guarantee of any of the information. It kind of like can be showing up at a court hearing on December 31st of 2012 without actually getting notice of the court hearing and then finding out that there was no court hearing. Now, as much as they don't guarantee, because I'm going to sue you for that, the state is required to give notice of court hearings, and then they're required to not have the court hearing unless they have proof of service. Now, it says mail or publication. Why don't we look? Ooch, ooch, ooch. Okay. Now, this was in, oh my gosh, 2013. Yes, yes, yes. What really happened is you put it in the newspaper, ooch, and because of the October 16th modification, yes, she said she sent it, but she didn't say where she sent it to, church. So your issuance of the well, why don't you stupid fuckers put yourselves in prison right now? Whatever happens to your personal lives, I just want you to know that I am going to sue every individual, organization, association, employer, employee, oath of office, mandatory reporter, and all of those that have any legal or professional obligation for the enforcement of the laws. And if you lose everything you owned and end up in prison, it's because you would not do what was smart. Why am I on trial in Jefferson County? Because this police department and sheriff's department, yes, wouldn't admit the evidence, which this state wouldn't admit the evidence, which the United States wouldn't admit the evidence. So whatever happens,